It's rather unfair to have kept you in suspense, isn't it? But we were very grateful for your submissions on that additional.
Thank you. Well, having had some emails from Mr. Malik, King's Counsel, over lunch, I think he's probably the person who is going to be most relieved, possibly. Before I do that, can I just say in passing, because of the fact you've had the statement, I had an opportunity to look on an electronic copy of the statement.
Yes.
You will see at paragraph 11 onwards that the presenting officer's characterisation of what the appellant was saying is incorrect, basically, because it's quite clear he is denying, consistent with the legal arguments being put, materiality. Yes. I'm not sure it could be.
This looks very much like a submission to me, but anyway.
Well, I think it probably is, but having been picked up the obvious concern of the court about there being a concession of materiality.
Yeah.
I mean, in one sense, and it goes to the question I was asked this morning about him giving oral evidence. In one sense, the actual main issue that's before this court about materiality, there's not actually much he can say about materiality because it's not his decision. But I didn't want to.
No, I understand. Yep. Thank you.
Turn to the law. Starting point in our submission, obviously, because it is obviously what governs the appeal is the British Nationality Act and the provisions of the British Nationality Act. Section 40 and Section 40A are in the in the bundle of authorities, rather, tab 36.
That was the second bundle.
Second bundle. Sorry, I haven't been referring to second bundle because
Thank you.
I'm not sure where it splits.
I think it was
Tab 30? Okay, I will refer then. This obviously was an appeal under subsection. Well, this was a decision rather taken under subsection 3.
Sorry, I haven't.
Sorry, it's page 1002 in the bundle.
Thank you. Yes, thank you very much.
A few features of that I should highlight. Firstly, ultimately there is a discretion, clear from the use of the word may. I highlight that because I would certainly argue that there is potentially a different approach required from the first tier tribunal in relation to the exercise of that discretion to the approach that's required in relation to what has been described as the conditions precedent.
Yes.
That's pretty much what KB Sri Lanka says, isn't it?
It does, yes, it does. Yes, I was going to make reference to KV. Yes, exactly. The second point is obviously that the condition precedent in subsection 3 is that there is a need for, it needs to be demonstrated, or the Secretary of State has to be satisfied with that language, and I'll come on to the word language of satisfaction, that the registration or naturalisation was obtained by means of fraud, false representations, concealment of a material fact. Clearly, linking back to the submissions this morning, there is a need for causation. Obviously, probably more importantly for the issues that arise in relation to Begum, the language it used in the statute is that the Secretary of State must be satisfied. That language, though, of Secretary of State being satisfied is found both in subsection 2, which is the provision that effectively was an issue, in Begum, which requires the Secretary of State to be satisfied that the deprivation is conducive to the public good, and is also present in subsection 4, which requires the Secretary of State to be satisfied of statelessness, or satisfied that rather the person, there is a prohibition, more accurately, on the Secretary of State making someone, depriving someone of citizenship if satisfied the person would be stateless. And I draw attention to subsection 4 for this reason. It is well established, and in my submission, Begum doesn't call it into question, In fact, Begum seems to have expressly endorsed the practice and case law making this clear. It is well established that in relation to subsection 4, an appellate body, either SIAC, where it's often considered, or the upper tribunal, considers directly for itself whether or not someone will be stateless.
It wouldn't be the upper tribunal, it would be the FTT.
First, sorry, FTT, and then,
Yeah.
yes, sorry, you're right. And that's obviously important because it demonstrates how there has to be limitations on what you can draw from the words satisfied. Because satisfied appears in subsection 2, where Begum applies, but it also appears in subsection 4. The right of appeal is enacted in subsection 40A. It says, on the face of it, nothing about the approach the FTT should take. It says nothing about the grounds on which an appeal will be allowed. Two points, though, that I would make is that, firstly, it does provide for rulemaking in subsection 3. We don't actually have the relevant rulemaking power in the bundle. We can provide that if necessary. It isn't any longer. In fact, section 106, because of the establishment of the FTT, it is now, as we understand it, the Tribunal Courts and Enforcement Act 2007. What we do have, just for note, and I can give you the reference, I don't think we need to go to it, is that Rule 6.3 of the FTT rules, consistent with the rulemaking power, clearly anticipate oral evidence being given. And that's something that's been picked up in cases. So there is a link between the appeal and the potential for oral evidence. Secondly, it was enacted, and one sees this from footnote 1, by section 40 of the Nationality Immigration Act 2002. And at tab 41 of the bundle, you have section 40, which obviously includes the original provisions of the original language of section 40A. You see that at 1048. 2 points about that. That was, as far as we're aware, and we have certainly put that in our skeleton argument, the basis for saying that, that was the first time an appeal had been provided for in this context. Although there'd been deprivation of citizenship before that, before the 2002 Act, it essentially had been an appeal to a committee. It hadn't been to a court, as we make clear in our skeleton argument. And so what would appear to us to be clear is that Parliament intended there to be something more than judicial review, which would otherwise be in place. I make that point because one of the arguments of the Secretary of State is essentially that there is good reason, essentially, why the approach of the FTT should be equivalent to judicial review. In our submission, that's inconsistent with the establishment of the appeal right. Secondly, the appeal that was established in the 2002 Act was an appeal essentially to the FTT, and although in the original section 40A, as with the current version, there is nothing that identifies the grounds of appeal or the basis upon which an appeal should be allowed, it was clear that generally the FTT would consider matters significantly beyond simply whether or not something was lawful in public law terms, and in particular would consider the way in which a discretion was exercised. And that's clear from the original terms of section 86 at 1053.
That's the 2002 Act.
That's the 2002 Act.
But it might be said that that appeal power isn't expressly conferred on the FTT in this appeal.
It's not. That's correct. I accept that's the case, but it's what one doesn't. What one still has is a deliberate decision by Parliament, or a clear decision by Parliament, that the appeal right should be to a body that is. It should be an appeal right, firstly, and it should be to a body that is generally equipped to review exercises of discretion. That having been said, in one sense, for my purposes, for the issues that arise in my case, of course, in one sense, the issue of discretion isn't directly an issue, because the issue is the prior question, the condition precedent, as it was described in KV.
But it might be an issue on remission to the FTT, because that was your second ground.
Absolutely. It would be an issue on absolutely.
Is Section 86 in the old 2002 Act anywhere in the amended Act?
The amended Act doesn't have the provisions that I'm drawing attention to, but that's because essentially, as my Lord will be aware of, the appeals have been now restricted very substantially, so they're just simply on Human Rights and Refugee Convention grounds. We can provide the updated Section 86, but the FTT's jurisdiction effectively changed when it became...
Well, and that's the point Lord Reed makes. Yeah.
Well, except that the point is a slightly different one in the sense that in relation to SIAC appeals, obviously when Section 40A of the British Nationality Act was first enacted, it provided for the alternative of a SIAC appeal. When it provided for a SIAC appeal, the equivalent of Section 86 had been repealed. Now that might make sense in one sense because, of course, in a national security context, and this is the point we're making, specific considerations arise. In the non-national security context, you had Section 86 still in place. So you had two different bodies which actually had different powers on the face of them when this power of appeal or when this right of appeal was enacted. For national security cases, you had an appeal to a body which didn't have the equivalent of Section 86. And indeed, the equivalent of Section 86 was repealed by the 2002 Act, as we point out in our skeleton argument. In the non-national security cases, you had an appeal to a new body that was being established for the first time to deal with immigration appeals, the FTT, or you had a new right of appeal, rather, albeit it was very similar to the previous rights of appeal, and that was one that included discretion. So there was a distinction essentially drawn between national security and non-national security.
So you're saying when the right of appeal was first introduced by the 2002 Act inserting the provision in the BNA, the provisions governing appeals to the FTT, Section 86, were different from Section 2, capital B,
yes,
of the 1997 Act, which governed appeals to SIAC.
Well, I'm saying yes, yes.
Yes, that's what I thought.
Yes.
Because Section 2B just says there's a right of appeal. That's all it says, effectively.
Well, sorry, that's the reason why I slightly hesitated. Both Section 2B and Section 40A say there's an appeal. Yeah. The difference I was just drawing was that when Section 2B was enacted, at the same time, same legislation, Section 5, I think it was, of the SIAC Act was repealed.
Section 4.
Section 4, sorry, yes. Section 4, which was the provision that said re-exercise discretion, that was repealed.
Yes.
And so you didn't have anything about the functions of SIAC and the...
I'd gather that.
So, sorry, that's the point of it. Yes, that's why I slightly hesitated, because the actual appeal provisions are very similar. It's what the body could do that changed, was different.
So just to follow up on that, is your submission that up until the changes made by, I think, the 2014 Act, the FTT on a Section 40A appeal could still review and exercise of discretion? Is that your point?
I'm not necessarily conceding that discretion was removed by the 2014 Act, but yes, it is our point that the Parliament had decided and this indicates the discretion could be reviewed, could be retaken. Parliament had decided that the appeal in non-national security cases should be to a body that was generally considering essentially the way in which discretion was exercised.
Yes, but am I right in saying that there is now no provision which enables the FTT to review an exercise of discretion on the...
That's right, yes.
Right, okay.
Yeah. The reason why I hesitated about saying that necessarily had an impact on nationality cases is that because Section 86 never directly applied in nationality cases, it was just talking generally about, in one sense, the jurisdiction of the first-tier tribunal. I don't necessarily accept, because I have to say, and I do say, that it was implied that Parliament intended there should be a review of discretion. Then I don't necessarily accept that the repeal of it had an impact on...
Right, just to follow that up. Well, so Section 40, capital A, subsection 3 of the BNA expressly provides that certain provisions of the 2002 Act shall apply in relation to these types of appeals. Did Section 3 at one point include the provisions of Section 8 by express reference?
No, if you go back, and that's the point, that's why I was picking up, if you go back to 1048...
Okay, 1048, yeah.
You will see that, in fact, as initially enacted, although enacted, and it's fair to say it's enacted by the 2002 Act, this is the provision obviously from the 2002 Act, as initially, this is the first version.
Which page of bundle is that?
1048.
1048, thank you.
Tab 41. You will see there that, and this is the Section 40A as initially enacted, it doesn't, the only reference to the 2002 Act, well, it's enacted by the 2002 Act, is simply to say that the rules made under Section 106 may make provision about an appeal under this provision. And so my point is not that there's a direct incorporation of Section 86, because I have to accept there isn't.
Okay, there isn't. Yeah.
My point is that what Parliament has done is in enacting Section 40A, it made the decision essentially that the appeal should be to a body, the FTT, that applied Section 86, and so was a body that was used to and did revisit discretion, essentially.
And is there authority showing that they had done that for these type of appeals?
No is the answer to that, in the sense that before, there's basically no authority before the 2002 Act, because there wasn't an appeal, and as far as we can work out, decisions just weren't, although in theory there was a right to review, decisions don't appear to have been taken. We cite Fransman on immigration, on nationality law, as suggesting there weren't decisions actually taken before the 2002 Act. After the 2002 Act, it isn't considered, I think, for some time, but KV represents the sort of pre-Begum state of the law, and what KV said, it may be worth going to KV just relatively quick. KV's at tab 19 of the authorities bundle, so that's the first bundle.
Just before you do that, Mr. Howard, I'm so sorry to interrupt. This is just to follow up on. Section 40, capital A, was amended, so I mean in quite a significant way, and subsection 3, which is the provision that incorporates by direct reference provisions of the 2002 Act, that has never incorporated section 86, is that right?
Sorry? That,
Has subsection 3 ever incorporated section 86?
not as far as I'm aware, no.
Right, okay, thank you. Sorry, I interrupted you again.
No, I was going to go to KV.
Yep.
KV's tab 19 of the first bundle of authorities, and the relevant page is 550. And actually, thinking about it, an answer to my Lord Justice Dingemans' question, actually, in one sense, KV is supportive of what I'm saying, because point 4 effectively says the tribunal should exercise its own discretion, albeit it recognises that great weight needs to be given to the assessment of the Secretary of State, which is may in one sense.
But what's the foundation for that statement?
KV, it cites a number of authorities, including Delisi, and I'll come on to Delisi because Delisi is dealt with by Delisi.
Referred to in Begum.
It's referred to in Begum, yes, exactly. It's dealt with by Lord Reed. But in any event, what he does make clear, as I say, and I would accept this, is that at Paris, what Lord Justice Leggett makes clear at subparagraph 6, within paragraph 6, is that in the issue of, in relation to discretion, weight has to be given to the views of the Secretary of State, considerable weight.
Yes, but he doesn't support that by reference to any particular provision of the legislation or the legislative history.
Doesn't, no, exactly, no.
Okay.
No. What is important about KV, though, is that in my submission, firstly, it starts from the premise that there is a difference between a review and an appeal. That's something which has, in my submission, survived Begum and indeed is referenced by this court post-Begum. It also makes the point, that's subparagraph 1, it also makes the point that the tribunal should make findings of fact. Again, I'm not sure that's in dispute. And the third point is that, which is probably the most important, is it distinguishes between what it describes as the condition precedent, that's why I use the language of condition precedent, and discretion. Not entirely clear, to be frank, what's meant by the condition precedent in relation to subsection 42, whether that means the issue of statelessness, which is clearly a condition precedent, or whether it also means that it's in the interest of, is conducive to the public good rather to deprive someone. But it's quite clear, obviously, about what it means in the context of subsection 43. And in our submission, there is clearly a distinction, and the Court of Appeal is correct in KV to draw that distinction. That's effectively where the law was pre-Begum. Okay. My learned friend asks me to draw your attention to paragraph 19
Of KV.
of KV.
Yeah.
Yes.
One other thing I should just draw attention to, which was sort of relevant as part of the background, but it really in our submission is in one sense, I was going to deal with it as part of Begum because it's sort of, in one sense, is we would submit the origin of Begum, is that before Begum, the courts, particularly the House of Lords in Raymond, had made it clear that specific constitutional issues arise rather where national security is an issue. And the authority for that is Raymond, which is at tab 1 of the authorities bundle, and particularly Lord Hoffman, paras 50 and 54. Now, what I would submit...
Sorry, 50 and 54.
Yes.
Do you want us to read those, or do it just...
Yes, para 50. If you could read para 50, and then I'll go to para 54 and highlight some passages from... Para 50 is clearly where national security is, as I say, identified as raising particular constitutional issues. Para 54, then, I draw attention to, because what Para 54 makes clear is that despite those constitutional issues, there is a role for an appeal. And in particular, there is a role, as is shown by letter D, for determining whether or not the factual basis for an opinion has been established. And that, in my submission, is important in this context, because obviously you don't have the sort of constitutional no-go area of national security. And what, in our submission, at the first stage of the process, which is what was an issue primarily in this case, albeit on remission, obviously there will be the exercise of discretion as well in issue. What was an issue here was essentially the factual premise for the exercise of the discretion. And that's why, in one sense, you can draw just a parallel here between the approach that was adopted, that has been adopted to statelessness, and the approach that should be adopted, we submit, to issues of fraud. Because effectively you need, there is a factual matter that needs to be established before the discretion can be exercised. And Lord Hoffman, in para 54 in my submission, the sentence starting first, is indicating in our submission that those sorts of factual issues are the sorts of things that an appellate process needs to determine whether have been an appellate process needs to determine whether they've been determined as a matter of fact or demonstrated as a matter of fact.
I'm not sure that's quite right in the case of statelessness. There's been a relatively recent decision of the Court of Appeal about section 44, is it? Where the analysis of the justice views is not that the Secretary of State has to be satisfied of any, that there have to be any facts have to be established. The Secretary of State has to be satisfied of something, and then at a later stage, the tribunal decides whether or not the something of which the Secretary of State was satisfied before exercising the discretion was in fact the case.
Well,
which is slightly different. I'm not expressing that very well.
No, So which possibly should have included that, but it, in one sense, doesn't go beyond al-Jeddah, which we included, which makes that point as well,
Yeah.
which is that on appeal, ultimately, well, in theory, there is a right to challenge whether the Secretary of State was satisfied, but the real issue on an appeal generally is whether or not the person is in fact stateless.
Yeah.
And the point I'm making, really, I suppose, is that, and this is, we would submit, consistent with al-Jeddah in particular, the point I'm making is that the real condition precedent under subsection 4 is the person stateless. That's a matter that ultimately the appellate body, whether it be the FTT or SIAC, needs to establish. In this case, the real condition precedent is, was there fraud that was material to the decision to grant citizenship? There's no real distinction between those two condition precedents. If SIAC or the FTT can consider one.
Yeah, no, I see the point you're making. Yeah. It makes it's not coherent for SIAC or the FTT to be able to consider whether or not the person is in fact stateless if they can't also consider whether or not they have in fact committed fraud.
Yes, and that point, the point I've just made, is also perhaps finds some support if you go to paragraph 57 and 58. Paragraph 54 of Lord Hoffman's judgment makes reference to the limitations of an appeal process. He deals with those in greater depth in paragraphs 57 and 58. And in 57 in particular, in the second point he makes is that where you're looking at the issue essentially of whether it's something that's conducive to the public good on national security grounds, there's no yes or no answer. Here, the second stage of discretion, there may be no right or yes or no answer, but the first stage, which is obviously the one I identified, there is a yes or no answer. I mean, either there was fraud or there wasn't fraud, and either that fraud was material or it wasn't material. And Lord Hoffman explains in paragraph 58 that the issue really arises because of the nature of the issue. Links in my submission back to, in particular, what he says, second point in paragraph 57, the point I've just highlighted. So that's the context of Begum, a previous House of Lords judgment that made it pretty clear that specific concerns, specific constitutional concerns, arose in the context of national security because of the constitutional significance of national security. And that fed into the appellate process, in part because, at the very least, weight needed to be given to the assessment of the Secretary of State. That's the context of Begum, and the key passages really of Begum are.
We're going.
Sorry,
just before you go to Begum, there's reference to Dennis. Was that only a UTAC decision?
It's an UTAC decision. It's also referred. I am going to come to it because it pops up at various points. Lord Reid in particular deals with it, and I was going to come to what Lord Reid says about it, basically.
Right. Sorry to interrupt.
No. Paragraph tab 21, page 616. sideline passages, which are the key ones really, are 66 to 71. But it may be worth just also noting, perhaps extending the sideline to 65.
Sorry, where do you want us to start?
At 65, probably. 65 makes the point I made earlier about, which is consistent with KV, about there being a distinction between appeals and reviews. And also it being relevant that in the context of appeal, there was an expectation potentially of evidence being given, so questions of fact being resolved.
Some appeals are by way of review, in any event. I mean, the White Book draws a distinction between appeals by way of review and appeals by way of rehearing.
That's right. The particular point being that's identified there is that in SIAC effectively had transferred to it judicial review functions in relation to certain decisions, essentially. It uses the language of review, but it's effectively a judicial review type function. But in Begum, what was an issue was a deprivation case, so it was an appeals like this, and so the language used was appeal. And my lord is, I think, referring in one sense to appeals within the judicial hierarchy, generally, where that's talking about a review. Here we're talking about, if you like, first instance appeals from an administrative decision, and the point Lord Reid is making is that within the SIAC system there are both reviews and appeals. In the sort of what might be described as the mainstream immigration context, the FTT only deals with appeals, but of course there are, if you haven't got an appeal right in an immigration context, you've got the right to apply for judicial review, so you get a review through that route. So there is a distinction, essentially.
Well, Lord Reid makes the point explicitly in paragraph 65 that sections 2 capital C to 2 capital E require SIAC to apply the principles which would be applied in judicial review proceedings. So there's an explicit requirement to apply those principles.
Exactly. So we're clearly in the appeal context. Now, what in my submission then Lord Reid goes on to emphasise is firstly in paragraph 66, particularly in the middle of paragraph 66, that what was an issue in a conducive to the public good appeal where statelessness, well, at this stage wasn't an issue, was discretion. And and he emphasises the fact that the Secretary of State is essentially responsible for the exercise of discretion. That's obviously, at the first stage, not an issue that arises in this context. He then goes on to, and this is the point that would be made against me, that the statutory condition that needs to be satisfied is one, before the discretion can be exercised, essentially is one that requires the Secretary of State to be satisfied about conducive to the public good. And that is, and that's not the same as a condition that SIAC should be satisfied. But ultimately, in para 67, what he's focused on still is the fact that ultimately this is a discretionary power of the Secretary of State. He's not dealing with the issue of condition precedent. And he recognises, in my submission, in para 69, by letter F onwards, that even in relation to a particular decision, different principles depend on what's in issue. And so consistent with that, if you go over the page to para 71, he makes it clear midway through para 71, starting with the words thirdly, that ultimately SIAC, which was an issue in that case, or FTT in this case, does determine essentially whether or not there's been compliance with the requirement for statelessness, or the requirement compliance rather in relation to statelessness is a better way of putting it. Certainly not suggesting that the Al Jeddah line authority that I'll come to in a moment has changed. So, what in my submission?
It's phrased in a way that suggests, that might be read as suggesting that the question is whether the Secretary of State was satisfied when the decision was made.
Well,
I mean, he's not dealing directly with that issue.
he's not dealing directly. I mean,
No.
he's certainly not saying that the approach in Al Jeddah is wrongly decided.
No, and anyway, it would be obiter because that wasn't an issue here.
Absolutely. What I gain from, I mean, fundamentally, the points I would take from this are: one, context is everything.
Yeah.
Two, it is relevant that something is an appeal process that can hear evidence. Three, it is also relevant that that it can be relevant whether what is in issue is a discretion. That may be highly relevant, because if what is in issue is a discretion owed, a discretion that Parliament has entrusted to a particular decision maker, then one needs to give, at the very least, significant weight to the views of that decision maker. You know, if Parliament has entrusted a discretion to the Secretary of State, it's not generally, unless there's express provision to the contrary, for a court to retake that decision, because that changes the nature of the discretion. And four, there are particular issues that arise in relation to national security. That means, in one sense, Begum doesn't deal head-on with the issues that then arise in this context, which is what is the nature of the exercise in this context. Now, two other points I should perhaps draw attention to. One is, I've been ducking the issue of Dalalisi. That is considered in the judgment at paragraph 41 onwards. Key point about it in my submission is that at paragraph 43, the Lord Reid cites from the judgment of the upper tribunal a passage which deals with the exercise of discretion and indicates that the approach of the upper tribunal in relation to the exercise of discretion was essentially to say that discretion can be retaken in the absence of express words to the contrary. That aspect of the reasoning is question may not be going far enough, but it is dealt with by Lord Reid, if one goes down the page, same paragraph, by letter F. Where
In paragraph 43.
In paragraph 43, by letter F, yes.
Thank you, sorry.
Starting with the words, however, the apparent reasoning.
So this reasoning is all addressed to the re-exercise of discretion. It's not addressed to the question whether or not there's been fraud. Is that right?
Yes, exactly.
Yeah.
It's rejecting effectively a conclusion of the upper tribunal that there's a presumption that where you have a discretion, you retake it.
Yeah.
In the absence. What perhaps the fifth principle I should indicate, that which is consistent with that I would draw from Begum, is that ultimately the approach that has to be adopted in relation to any appellate jurisdiction depends on the statutory framework and what the statutory framework says about what is in issue.
Do we get anything from paragraph 42?
I'm not sure. I'm not sure why, my lord, in the sense that.
Well, what's set out by the view of the first tier tribunal? The first tier tribunal could examine the facts, examine the evidence, and determine whether the basis on which the decision was made out. Is not criticised.
It's not, albeit I'm not sure that in one sense. I mean, that supports me, but it doesn't take. I don't think it takes.
Don't read too much into it.
Yes, I'm not sure it takes.
An FTT decision in part which was disapproved later.
Yes, for other reasons, but.
But was the only issue in the upper tribunal whether or not the FTT should have re-exercised the discretion, or was there an issue in the upper tribunal about whether or not the FTT was right or wrong to examine the factual basis of the decision?
We have Delalisi at tab 8. My memory is that it's simply about
the
re-exercised discretion, but and just on a quick look. At the head note, the head note focuses certainly. That's the upper tribunal's head note, focuses on the exercise of discretion.
Yeah.
Okay.
So that's what it's always been seen as. The other point that I'd just draw attention to, at para 81 of Lord Reed's judgment, going back to Begum, para 21, sorry, tab 21.
Sorry, which paragraph?
Para 81.
81, thank you. Yes.
Is that Lord Reed endorses and indicates it's not inconsistent with his judgment, the approach of Lord Sumption to review that was set out in FAM. See, it's set out. This is from FAM, from para 80 is the reference to FAM. Lord Sumption, as is clear from sort of the second half of Lord Reed's judgment, where he doesn't indent but then quotes another bit of the judgment of Lord Sumption, makes it clear that there is that the common law test for rationality is context specific. So there are some things that courts are just better equipped to assess than others. What actually Lord Sumption goes on to say in FAM, and I don't think I need to necessarily take you to it, but it's in the bundle of authorities, the relevant paragraph, is that there are some circumstances where the court's competence means that effectively there is only one rational answer. In other words, the court is deciding for itself the outcome of the case. That, I mean, an alternative, our primary position is that the court, in relation to issues of fraud, etc., should be the primary decision maker. But an alternative way of looking at this is that even if ultimately there is a review, one has to take account of the nature of the issues. And where something is purely objective, as we submit the first stage in this context is, there's no reason in one sense why the review shouldn't be sufficiently intensive that effectively it amounts to very much the same thing as fact-finding. There is only one rational issue, one rational approach.
Well, is that necessarily right?
Well, in the passage that's quoted by Lord Reid, Lord Sumption identifies 3 issues that are relevant when determining the intensity of review. Firstly, the significance of the right.
Yeah.
The right is, an issue here, is the continuation of citizenship that an individual has obtained. The second is the degree of interference. Well, it's the complete denial of citizenship. And thirdly, the which he says is perhaps, which he indicates is a notably significant factor, is the competence of the court. And if you're talking about issues such as whether there was a fraud and whether it was material, that is the sort of thing that courts are, in our submission, particularly well equipped to decide. I mean, if you've got a spectrum with national security at one end of the spectrum, the sorts of issues at the first stage are the complete opposite end of the spectrum.
But in this passage of judgment, Lord Reid is dealing with the balance between a right to nationality and the relevant public interests involved. He doesn't seem to me at first sight to be dealing with questions of fact and the ability of the tribunal to make findings of fact. And that's got nothing to do with intensity of review. It's a different exercise.
Well, except in this sense, our primary position is consistent in one sense with the question that you're putting to me, which is that because of the nature of the issues, and because of the fact that ultimately this is a straightforward fact-finding exercise, this isn't about reviewing the Secretary of State's decision-making at all. If I'm wrong about that, and if even at the first stage there is a need for a review exercise, or rather the FTT is limited to a review exercise, then the question then becomes, in my submission, what is the intensity of the review? Because what Lord Sumption was indicating fundamentally in my submission is that there's not one size fits all approach to review. So, I mean, that's why Lord Reid rather focuses on the significance of national security, because national security is at one end of the spectrum. All I'm saying is that if you end up disagreeing with me about my primary position and conclude that in relation to all aspects of what was an issue on this appeal, the question is the rationality of the Secretary of State's approach. The approach that was endorsed by Lord Reid and initially identified by Lord Sumption suggests that what's in issue here would be a very intense review, which may well be effectively the same as fact-finding.
Right. Well, all right.
But that's not, as I've indicated, that's not my primary position.
No.
Begum has been considered, as far as I'm aware, by this court twice. It was touched on in Lackey at tab 22, where Lord Justice Underhill declined to deal with it. Essentially, I probably don't need to take you to it, but for the note, it's paragraph 40. In any event, that was a case which was essentially about the discretion. It was then touched upon by this court again, presided over by my lady, by Lord Justice Beam, but with my lady delivering the leading judgment in P3.
Okay, which one?
P3 is tab 25.
Thank you.
My lady identified how, in one sense, the issue of Begum arose at page 716, para 95 to 97.
Sorry, which tab was that, please?
Sorry, 25.
Sorry, my fault. several steps behind the beat as usual.
No, I'm probably going too fast.
So I forgot the paragraph numbers again.
Sorry, it's 95 to 97.
Thank you.
Where my lady identified what was the primary issue in Begum, which it doesn't really arise in this case, which was to what extent was there a real difference of approach between the approach SIAC was required to take in a human rights case and the approach it was required to take in a case where human rights weren't an issue. But it's important to note, I mean, one of the reasons for going to this, the only real reason for going to this, is that in paragraph 97, my lady notes the limits on the institutional capacity of SIAC to review the Secretary of State's assessment of the issues of national security, demonstrating again, in one sense, the particular issues that arose in Begum that don't obviously arise in this case. That then feeds in to the approach my lady adopted in the postscript to the judgment at para 114. And particularly the last four lines rather, of paragraph 114. And in one sense, that's the key point, is that Begum, as the passages I've taken you to indicates in my submission, is context-specific. It is focused on the exercise of discretion in the context of a case where that discretion was being exercised for reasons of national security. As a result, in my submission, it doesn't touch on the approach in KV, which in my submission remains essentially good law, and which set out the approach in cases where national security isn't an issue, but particularly in cases where primarily an issue is the condition precedents, the need to establish in this context fraud and material fraud.
So the word material isn't used in the statute, is it?
No, I use material because that's used in the policy, but it does reflect, it's a useful shorthand for the statute talks about.
Let's just go back to the statutory language.
Yes, it's tab 36.
Yeah.
Well, the statute requires the fraud to have been operative.
By means of, yes.
Yeah, which is another way of saying material.
That's why I was using it as shorthand law. Yes.
Yeah, but we need to remember that material comes from the policy, and the primary test is the test in the statute.
Yes, and that's obtained by means of.
Yeah. Okay. Thank you.
The argument that there is a distinction between national security and other contexts is supported by the concurring judgments of Sir Stephen Owen and Lord Justice Bean. If you go to para 126, so Stephen Owen, in the first sentence in para 126, recognises the need for great deference in relation to national security, but below letter E distinguishes between high policy, as he describes, and more granular issues. That language is essentially repeated by Lord Justice Bean at para 135. And so what I would submit at this level, the case law indicates that Begum, as I've already submitted basically, is concerned with a relatively narrow issue, which is the approach that SIAC in particular had to take in national security cases where what was an issue was deprivation on national security grounds. As a consequence, in our submission, no basis has been identified for going behind KV, and KV should as a result continue to be followed. And KV in particular should be followed in relation to the key issue, which is the distinction drawn between condition precedents, to use its language, and discretion.
And that's paragraph 19 of KV, is that?
No, it's the earlier paragraph, the one which had the sub-paragraphs. I think it's 6.
I think it's paragraph 6, isn't it?
Yes. It's the one that had the sub-paragraphs.
Thank you.
The upper tribunal has considered the issue now on a number of occasions. I'm not going to take you to all of them because a number of them don't have a huge amount of reasoning, and they're obviously not binding. The first judgment considering it though, was Cherry, which is a decision of Mr. Justice Laing, who was then president. Cherry is at tab 24, and the relevant passage is really page 690. He looks at KV and modifies KV without a huge amount of reasoning with respect to the judge. In paragraph 30, subparagraph 1.
Is it up to him to modify KV?
Well, that's one sense why I'm... I mean, it would be open if Begum clearly, by implication, concluded that KV was wrong, then it would be open to him to. If KV couldn't stand with Begum... Your
submission is that's not...
That's not right. Yeah. So, yes, I wouldn't accept that is open to him, but I suppose in principle it might be. And that's the approach he's without much reasoning, with respect to the judge, has adopted. He just concludes Begum has changed the approach. Slightly greater reasoning is provided in the more recent, perhaps more than slightly, but a greater reasoning is provided by the current president in the most recent authority you have in your authorities bundle, which is in the second bundle at tab 34, Chimmy. And that's Mr. Justice Dove.
I'm so sorry, I didn't catch the tab.
Sorry, tab 34.
That's my fault, thank you.
Page 984. And he, it's para 49 really onwards, where he deals with the condition precedent and whether or not.
So, sorry, what was the issue in this case?
The issue in this case was I think this was a fraud case, if I remember rightly.
Section 40, subsection 3.
3, yes, it was a fraud case. It essentially the background was, I remember now, it was discovered that the individual had effectively obtained status in the United Kingdom using a false French identity.
So you should use a false document.
Yeah. Going back to this morning's arguments, as I understand it, it doesn't really shed a huge amount of light on the issues from this morning, because her status had clearly been obtained using the
Yeah.
But what that did mean was that Mr. Justice Dove, as I say, needed to consider what he described as the condition precedent question, and the argument appears to have been, particularly from paragraph 50, that essentially primary argument appears to have been that Begum was about national security, and he declines to distinguish Begum for 3 reasons. Firstly, that Begum depends in part on the use of the word satisfied in subsection 42. You see that at para 51, which of course is correct, but can't take one necessarily very far, given the point I made before, which is that satisfied applies to statelessness. He relies on the disapproval of Delelisi. I've taken you to that, and Lord Reid there is focused in my submission on the, in particular, the findings essentially about discretion. And thirdly, he rejects an argument that there's a qualitative difference between section 43 and section 42. In my submission, that simply is wrong on the basis that in the Begum context, subsection 42 raises these issues of constitutional importance, as Lord Reid was making clear, as probably more clearly Lord Hoffman was making clear in Raymond. Because they raise these issues of national security. Subsection 43, the condition precedent in particular, raises no issue of constitutional importance. It raises a factual issue, which courts, as I've already indicated in our submission, are well equipped to address.
So what approach did he say should be adopted?
He said effectively that in relation to those issues, the issue should effectively be a public law issue. The issue is, was the Secretary of State entitled to reach the conclusion?
What about the proposition that on the appeal you can have further evidence? How does the further evidence fit with a public law review?
Well, that's something that in the SIAC context has caused a lot of concern, and indeed, I think my lady, may have been involved in the recent hearing in U3. I don't know whether anyone else in this panel was involved in U3.
I certainly was.
Yes, which deals with that, seeks to deal with that issue. I mean, it is, on the face of it, the ability to hear evidence makes it very difficult to apply public law principles, because how do you? I mean, in this particular case that we've got before us, in one sense, there wasn't any extra evidence because the representations were made, etc. But in principle, you could, for example, have a witness come. I mean, if there's an issue, for example, about whether something was fraudulent, you could have a witness suddenly arrive who says, well, actually, this individual was always telling the truth.
And it might have been perfectly reasonable for the Secretary of State to have been satisfied on the material that was there before her.
Yeah.
And but there's no test for fresh evidence. You should have adduced this before the Secretary of State.
No. There is a test from memory that it has to relate to things in existence. So for example, in relation to the exercise of discretion, if you say it's now 2 years after the decision, and I now have a child, and this child will be prejudiced by the fact I'm not a British citizen, then you would have difficulties getting admitted unless it was foreseeable at the time. But if you say you didn't know at the time, but I have this witness who's a witness to the alleged fraud and demonstrates it wasn't fraud, there's no reason why you can't admit that, you can't have that evidence heard. And that's one of the reasons, and Lord Reid identifies that in Begum, that's one of the things that is potentially highly significant in working out what the approach should be. And actually thinking about it, one of the areas where that is most commonly an issue is in the issue of statelessness, the KV type situation, where the Secretary of State will make an assessment of statelessness, quite often with limited material. By the time the matter comes on appeal, there may be significant, certainly in the SIAC case, there would normally be significant experts from both sides describing the law of the citizenship law of the country in question. And as a result, it becomes very difficult to see how you would apply public law principles to that issue of statelessness, even though the test in the legislation refers to the Secretary of State being satisfied. The authority that I referred to in relation to statelessness as being the origin is Al Jeddah. I won't take you to it. It's at tab 9.
Sorry to interrupt. Maybe what one needs to do is to distinguish between the position when the Secretary of State takes the decision. In other words, the Secretary of State has to be satisfied of X or Y, fraud or state or in relation to statelessness, and the position on the facts as established after the appeal. I mean, that's your basic. I think that's what you're saying. There is a distinction between those two things.
Yes.
And if nothing's changed, and the Secretary of State didn't make any error, then the tribunal's very likely to come to the same decision anyway.
Well, yes, although there is still a distinction, and it goes to the point I made before about discretion. In the context of discretion, if you look at assume for the moment that there was fraud in this case, and assume for the moment that was material, which is obviously not our case. The third issue is discretion. Now, in that case, the Secretary of State will make a policy judgment, and the policy judgment will be either here the fraud is sufficiently important to justify taking action against you, or it's not sufficiently important. In that circumstance, then quite clearly, and this is what KV says, the judgment of the Secretary of State will carry a significant amount of weight. It won't be binding, but it will carry a significant amount of weight. At the first stage, which what we're talking about, although the Secretary of State will have the same material, the reality is, conceptually, same as statelessness, either there was a fraud, and either it was material, or there wasn't a fraud. There's not really any judgment to exercise, and that's where there is scope for the first-tier tribunal or SIAC to reach a different conclusion, because ultimately it's looking at the pieces of evidence and concluding what they demonstrate. So there is more scope in that first stage for disagreement, even if the material doesn't change. I think that covers everything I need to cover, but that's why we say ultimately, KV remains good law.
Can I just ask one question about the statutory provisions?
Yes.
We've obviously got Section 40, which governs this appeal.
Yes.
you mentioned rightly that there had been a change after the 2002 Act to restrict other appeals to the FTT to protection and human rights grounds.
Yes.
Those provisions didn't impact these type of appeals.
No.
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 So we're not trying to marry in the appeal on a condition, a precedent fact to be human rights or anything.
No. I mean, there may be human rights issues that arise,
Of course. Yeah.
but no, the appeal remains the sort of unspecified appeal effectively within such. It has always been that unspecified appeal in subsection.
Whatever it means.
Whatever it means, yes.
Thank you.
We've given the question my lady asked, my learned junior very helpfully has been through just to double check the assurance I gave you about section 48. In fact, I'm told that tab 57, all the versions of section 40A are, and none of them refer to section 86.
Right, that's helpful. Thank you very much. That's very helpful.
Thank you.
Yes, thank you.
Thank you, my lord. I was proposing to take things in the following order. To start, first of all, with 3 headline points. Second, to make some very brief points on statutory framework to put the facts of this case in context. Third, just to flesh out some points on the facts. And finally, to deal with the substantive issues. And I was proposing to take those in the same order that Mr. Southey did.
Thank you.
So could I then begin by making 3 headline points? And our submission is this, that in relation to the appellant's ground of appeal, the straightforward issue is whether the first-tier tribunal erred in law. That's what the upper tribunal was required to consider under sections 11 and 12 of the Tribunal's Courts and Enforcement Act 2007. And for the court to note, those provisions appear at tab 39 of the authorities bundle. Now that question does not involve criticism of the first-tier tribunal necessarily. It's simply a question of whether it erred in law. So take a situation, for example, where there's a binding decision and a lower court makes a decision based on that decision, and it then goes to a higher court. Nobody's criticising the lower court, but what the appeal court is doing is looking at the law and looking at whether there's been an error of law. So we've held our hands up from the beginning of the case in this court and said it's regrettable that the Home Office presenting officers didn't assist the first tier, but this is not about criticising the first tier. It's about looking whether it went wrong in law, and we say that clearly it did. So that's our first headline point.
Yes.
The second headline point is that I'm going to take the court to case law, which we say effectively shows that Mr. Southey's reliance on what he called example B, and he said it was the high point of his case, is simply wrong. Because there is case law, and while some of it postdates the decision of the first tier tribunal in this case, it's case law which tells us about the legal position at the time the decision on ILR was made in this case. And I will show the court that makes absolutely clear that this appellant benefited from his fraud at the stage of ILR. And the third headline point then is tied to the second, which is Sleeman turned very much on its own facts, and in this case the upper tribunal was clearly right for the reasons it gave and for other reasons to set aside the first tier decision.
But that wasn't on the basis of your point B.
No, that's to deal with, I think, what is a separate argument from Mr. Southey that Sleeman doesn't matter because he's right in any event.
Yes.
So before I go to the facts, and what I'm going to do with the facts is take the court through the three key decision-making stages in this case and show the court the law. But before I do that, could I just set things in context by making a couple of brief points? Firstly, about acquisition of citizenship, and then second, in relation to deprivation. And this won't get into points about Begum, I'll come to those later. It's just to make some high-level points at the outset. So in relation to acquisition of citizenship, the court has, at paragraph 24 of our skeleton argument, the relevant provisions which govern success of the application. So that's section 6 of the 1981 Act and schedule 1 to the 1981 Act. And if the court wants to look at those, they're at tab 36 of the authorities bundle. Page 1009 is section 6. So this essentially tells the Secretary of State, when a person makes an application for naturalisation or registration, whether that application should be allowed. So section 6.1, I'm sorry, it's page 1001.
Yes.
If on an application for naturalisation, blah, 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 the Secretary of State is satisfied that the applicant fulfils the requirements of Schedule 1 for naturalisation, he may, if he thinks fit, grant to him a certificate of naturalisation. And then there is a good character requirement, and just so that the court knows where that comes from, page 1009, paragraph 11b.
So this is, you've taken us to Schedule 1.
Yes. So what this says is 1.1, subject to paragraph 2, the requirements for naturalisation as a British citizen under section 6.1 are, in the case of any person who applies for it, and the central relevant condition here is B, that he is of good character.
Is that defined?
It's not defined, but there is case law, and I will just highlight the salient points of that case law because it's very well established case law, both in the administrative court and in this court, about what that means and the relevant standards so far as scrutinising decisions of the Secretary of State.
Yes,
So
because obviously in criminal courts you have good
Yes.
character and immaterial sort of previous convictions, etc.
Indeed. So that's probably a convenient point, just to take the court to paragraph 26 of our skeleton argument, where I've tried to summarise the key principles from the case law. So paragraph 25 I should start with, that the essential starting point is that there isn't a right to citizenship, but only a right to have an application fairly considered under the statutory scheme, and we haven't included that authority because we didn't understand that to be in dispute. And then, in relation specifically to good character, the well-established principle set out in our skeleton at paragraph 26.1 is that if the Secretary of State isn't satisfied that the person's of good character and has good reason not to be so satisfied, she's bound to refuse the application. I don't need to take the court to SK, but for the court's note it's at tab 5 and we've given the relevant paragraph number. And then to take our points 2 and 3 together there, it's well established that you can only challenge a good character decision on ordinary public law grounds, but importantly the Secretary of State enjoys a significant margin of appreciation in that respect. So what a claimant can't do is say, well, that all seems a bit steep, that's not really a fair way to define good character, and that's the case of DA Iran, which is at tab 10 of the bundle. And the second proposition there is also well established, which it's not for the court to discourage ministers from adopting a higher standard in that respect, provided it's one which can reasonably be adopted. And that there are many authorities where people fail in challenging a good character decision.
And is Al-Fayed number 2 in the bundle?
It's not, no, but
No.
we can certainly get that overnight.
No, it's fine. It's fine. I just wanted to check whether it was.
No, it's
I mean,
not.
it's pretty standard.
Indeed.
Yeah.
I was conscious of not burdening the court with authority, so we only included those two. The proposition at 26.4, which is the point that whether the Secretary of State is satisfied that an applicant is of good character is an evaluation or judgment on the part of the Secretary of State. That pretty much is what the case of Amin says. I think it's a judgment of Lord Justice Lewis. So we haven't included that in the bundle because that's what it says. And I'll come back to the forms and the guidance when I come to the facts of the appellant's case. So that's essentially acquisition and good character. And then in relation to deprivation decisions, we've made the point in paragraph 29 of our skeleton argument that Parliament takes fraud very seriously because unlike where a decision is made on the grounds that deprivation is conducive to the public good, the section 44 provision about statelessness does not apply. So the provision which says the Secretary of State has to be satisfied that the person won't be stateless does not apply in a fraud case. Should I show the court?
So in other words, the Secretary of State can deprive someone of their nationality on fraud grounds, even if the consequence would be to make the person stateless?
Yes.
Okay.
And we say that shows the seriousness with which fraud is viewed, because as I asked Mr. Southey to show the court, paragraph 19 of KV, if the citizenship has been obtained by fraud, then the person was never entitled to it.
Yeah.
And just for the court to know, that proposition is repeated in the, I'm not sure if it's Lackey or Lassie case that Mr. Southey mentioned earlier. It's at tab 22. Could I just ask the court to note, and I don't need the court to turn it up, that at paragraphs 37 and paragraph 73, the Court of Appeal makes similar comments in that case. So that then takes me to the third part of my submissions, which is to draw out some more points on the facts and the law, the historical law. And I'm going to deal with this in three parts. First of all, the grant of ILR to this appellant, which was in 2010. Second, I just want to make some points about the naturalisation application and decision, which was in 2013. And then finally some points in relation to the deprivation decision. Now, although I've called this an analysis of the facts, what I need to do to help the court to understand the facts is show the court the law as it was in July 2010 when the Secretary of State was considering this appellant's application for ILR. And it's accepted by Mr. Southey that at this point, when he was making this application, he lied, and or he kept back from the Secretary of State the fact that he had lied about his nationality. So it's common ground that at this time he continued to assert a false nationality. And we submit that the appellant's submissions do not correctly reflect either the case law or the decision-making process on this issue. So the quickest way for me to show the court how this works is to ask the court to turn up the authority of Natusha, which is at tab 23 of the authority bundle. So So this is an upper tribunal decision. It's a case with similar facts to this one, but it's about revocation of ILR because the deception came to light sooner than it did in this appellant's case. So could I ask the court first to look at the facts in paragraphs 5 and 6? And the court will see that this is a person who also came to the UK in 1999 and falsely claimed that he was born in Kosovo.
Yes.
And then there's some description there of the background in terms of asylum claims. What the court then goes on to set out is the legacy programme, what the legacy programme was and what considerations were applied before a decision was made under it. And what a whole series of case law shows is that the legacy programme was essentially to deal with a backlog in applications, but it was not an amnesty. And I'll show the court that. And when decisions were made as part of the legacy programme to decide whether someone should be granted leave, character was taken into account. And that's the very issue which is being considered by the court in this case. So just for the court to note, there's a detailed description of the legacy programme in paragraph 11, which is actually a citation from 2 administrative court decisions. And the court has one of those, Geraldo, in the bundle. We've footnoted in our skeleton that there was a lot of case law about the legacy programme and what it meant and what rights it confirmed, and that ended up ultimately in the court.
Some of the litigation.
Yes, yes. It went on in our footnote 1. We haven't included it in the bundle, but ultimately it culminated in a decision of this court in the case, I think it's called SH Iran, and we've given the citation for that at footnote 1. I can bring it, but I'm not sure the court needs it because I think the court can get everything that's needed from this Matusha decision. So that's paragraph 11 and references there to Hakimi and Geraldo. And then the court will see that in that case, at paragraphs 15 and 16, what the upper tribunal does is look at the Secretary of State's internal notes. And I'm going to take your lordships and your ladyship back to those in a moment once I've set the scene. Paragraph 19 is important. Paragraph 18, facts are the same as here. The applicant continued the deception in what he considered to be an application for leave to remain under the legacy programme. Now, the reason that's described as considered to be is because people didn't actually make applications. Essentially, they were just considered when it was their turn. And just reminding the court that this case is about looking back whether, as a result of his fraud at the time that he made his legacy application was considered, he should be deprived of the leave that was given to him. So paragraph 19 sets out the legacy programme didn't purport to set out any new substantive rights or a new basis for leave. It was an operational exercise with the broad objective of resolving the backlog. So this applicant was granted ILR on the 12th of August 2010. Our appellant, it was July 2010, and at that date decisions were made within the framework of paragraph 395C. Now it's set out here. The court has the version in place at the time of our appellant's decision at, just for the court's note, authority bundle tab 47, 1124, but so far as I can see it's exactly the same as...
It's surprising if it were different.
Yes,
between July and August.
Quickly. There was a new... there was also policy guidance.
Right.
But again, I've looked and I can't see that there's any relevant difference, but if the court would like, we can provide the actual copies. But what the court will see is 395C. What happens is when the Secretary of State's deciding whether leave should be granted, the Secretary of State looks at 395C of the immigration rules, which says before a decision to remove is given, regard will be had to all relevant factors. Age, length of residence, strength of connections, and then importantly, 4, personal history, including character, conduct and employment record. And then the court sets out what the policy guidance said at the time. Second paragraph at the top of 661, relevant factors are set out in 395C and in the guidance below that this list is not exhausted. And then paragraph 22, just above the bottom hole punch, there's a however. However, the programme was not an amnesty and not all negative factors were waived. It's clear that the personal history of an applicant, including evidence of deception, still form part of the assessment. So that's the upper tribunal telling us that. And then it quotes the guidance. And then at the top of page 662, case owners must also take account of any evidence of deception practised at any stage in the process. And then a few lines down, the case owner must assess all evidence of compliance and non-compliance in the round. And the tribunal tells us that the nature and extent of negative factors still form part of an evaluative assessment of whether it was appropriate to grant leave to remain. I should have said this is a decision of the President, it's a presidential panel. So paragraph 26 then, in looking at how decisions were made under the legacy programme, could I just invite the tribunal please to read paragraph 26, the court to read paragraphs 26 and 27.
So somewhere or other it's set out, paragraph 395C was used for the purposes of deciding whether or not to grant indefinite leave to remain under the legacy programme.
Yes.
Is that right?
Yes, exactly. And it's, that is set out in paragraph 19 of this decision. The tribunal explains that at that date decisions were made within the framework of paragraph 395C. But
I know, I find that a bit opaque myself.
Yes, it is how it worked. I could probably find a better reference in one of the other cases.
But that's the caseworkers were told there was still an element of the exercise of judgment when deciding whether or not to grant leave under the legacy programme.
Exactly, and conduct and character were relevant, and we'll see that from this case.
Yeah.
Well, there's a reference to it in the GSID notes.
There is, yes.
Yeah.
So this case considers the GSID notes, you'll see. And at this point, in August 2010, in this appellant's case, just as in our case, the Secretary of State was not aware that the person had lied and said they were Kosovan when they weren't.
Yes.
So exactly as in our case, there's analysis, is the applicant of good character? Yes. Has the applicant complied? Yes. And then at 31, the tribunal points out the decision was made in ignorance of a relevant fact, that the applicant lied about his nationality and age when he claimed asylum and continued to maintain the deception.
Yes.
So what then happens is this appellant comes unstuck at the naturalisation stage.
Yes.
Because at that stage inquiries are made and it turns out that he's lying.
Yes.
So he's refused on good character grounds. Now that pausing there, of course, we say that's what should have happened in this case if this appellant hadn't hidden the fact that or continued to maintain his lie. Because this case, it rather illustrates the point that this kind of deception will get somebody refused on good character grounds. So he was refused, but what happened then is he made a further application, and the Secretary of State was not satisfied with simply having refused his naturalisation application, but took the deception so seriously that she took action to revoke his ILR.
Yes.
So that then is what this finally what this case is about, at paragraph 39, the court will
Yes.
see there was a decision to revoke. And importantly then, could I invite the court to turn to 50, paragraph 50 sub 1, which was one of the issues in this case.
It's interesting the wording in section 76 is different.
Yes.
Yes, sorry, which paragraph?
Paragraph 50, subparagraph 1, one of the issues was whether the applicant's deception as to nationality and age would have been directly material to the grant of ILR.
Yes.
And it was not a dissimilar argument advanced in that case to the one that was advanced here when the appellant was making his representations, and indeed an argument that's been maintained. Paragraph 52, just above the bottom hole punch, Ms Naik submitted that the way the legacy programme operated was quite different. The applicant's skeleton argument went so far as to say that the fact the applicant lied about his nationality and age was wholly irrelevant to the criteria for granting ILR. The main reason for the decision was the applicant's length of residence. And the tribunal rejects that. We do not agree that his repeated and long-standing deception relating to his nationality and age would not have been material to the assessment under the legacy programme had the respondent been aware of it at the time. The legacy programme didn't operate as an amnesty, nor was there any clear policy for granting leave, save for the usual criteria considered under paragraph 395C. That may answer my Lord Justice Moylan's question just now, and chapter 53, albeit those criteria were assessed through the operational objective of reducing the large backlog of cases. And then at 54, at the bottom, last 3 lines, caseworkers had to take into account any evidence of deception practised at any stage of the process. What that results in at paragraphs 57 and 58 is this tribunal deciding that the ILR should be revoked. Could I perhaps just invite the tribunal to read, the court to read 57 and 58?
So this was an application for judicial review decided by the upper tribunal, and the application concerned the decision to revoke
Yes.
ILR.
Yes, that's right.
Thank you.
A lot of the arguments in this case featured from the fact the Secretary of State sat on the case for 5 years, which allowed other arguments to flourish.
Yes, although the key, for present purposes, what it shows is that deception was taken seriously. The other point then to mention is that in paragraph 59, the court gives the example of Hakimi. Now, Hakimi is a case which was decided, I think, back in 2013 or 2014. And that's an example of somebody who didn't even manage to get leave under the legacy programme because of a lie that they were from Kosovo. So could I also invite the court just to read 59? So there were several, just to explain, there were several claimants in Hakimi, and Mr. Mustafa was one of them. situation where Mr. Mustafash tells the truth and doesn't get leave at all. Mr. Matusha is found out once ILR has been granted before citizenship and gets his ILR revoked. And our appellant, by continuing his lies on several occasions, including in his citizenship application, avoids the consequences that befell Mr. Mustafash and Mr. Matusha. And we say that really blows any argument out of the water that this is an example B case, and I'll take the tribunal to that when I look at the naturalisation application. But it's wrong in my submission to say, yes, that it's all about Sleeman and there weren't any other cases, because there may not have been. There certainly Hakimi had been decided, but it's not so much the case law as the fact that paragraph 395C of the immigration rules was in place, and that required character and conduct to be considered. So what we know from this case, and the tribunal goes on at paragraph 60 to say, but for the continued deception, a case would have been properly assessed by reference to negative factors. So that puts that in context. Could I then now ask the court? I'm spending too much time in tribunal authorities.
No, I think we're sometimes referred to as the tribunal, so I wouldn't worry at all.
That's correct.
And in a sense, we are a tribunal.
And as I said, we are.
That's correct, but I can assure your lordships and your ladyship, I do realise I'm in the Court of Appeal today. Paragraph 38 of the supplementary bundle, just now to take the court back to the SID notes.
Sorry, the supplementary bundle.
Supplementary bundle.
Page.
The SID notes begin at page 38,
yes.
but the key passage
41,
begins at
printed.
40. So that's why then...
Sorry, we've got printed numbers. And so are you going by the printed or are you going by the numbers on the document itself?
Numbers in the middle or numbers in
Okay, yes.
Yes, so it's ignore the big jumbo numbers.
Yes.
Unfortunately, it's the smaller numbers,
yes.
page 40 in the middle.
Right.
So, but just at the top of that page, consideration of chapter 53 by the top hole punch.
Sorry. Consideration of chapter 53.
Yes, so that's
yes.
chapter 53 that we've just seen referred to in Matusha.
Yes.
A few lines down, nationality Kosovan, so we see that the line
yes.
is still being maintained. And then, is the applicant of good character? And that's why I asked Mr. Southey to take the court to that.
Yeah,
to that
at the
part.
bottom.
Yes.
Yes.
And the Secretary of State says yes and yes.
Yes.
Now we know.
Complied. Yes.
Yes, we now know from looking at Matusha and also the Mustafash case considered in Matusha that the Secretary of State did not take the view that the person was of good character if they had lied about their nationality. And we see then, so the Secretary of State mistakenly directed herself that this applicant is of good character because she doesn't know about his lie. Certainly she hasn't been given a chance to consider it because the applicant has lied and therefore avoided that
yes.
risk. And then bottom hole punch, personal history,
yes.
including character, conduct and employment record, no evidence of personal history. Well, of course, there's nothing for the Secretary of State to say more about character.
Sorry,
because
is this page 41?
I'm so sorry, yes, page 41, bottom hole punch.
Personal history, got it, yes.
There's nothing for the Secretary of State to say there because she doesn't know yet that she's been lied to.
Yes.
And then the court will see, if the questions are all answered yes, then it's a straightforward decision. The decision can be made by an AO or an EO, but if there's no to any answer to the question, it goes up a grade, basically. So that's why...
I'm sorry, there's a specific reference to 395C of Chapter 53.
Yes.
Sorry, outside the rules under 395C.
I don't know why there's a mistaken...
Right at the very
yes.
penultimate paragraph.
Oh, I see, yes, yes.
But there's a mistaken
Miss
reference
S's
there.
length of residence.
There's a mistaken reference there to a Miss S.
It must be Mr. S.
Yes,
It must
exactly.
be a typo for Mr. S.
It's Mr. S.
Yeah.
So that's the reference to 395C. So we say absolutely his continued lie, at the very least, had a material bearing on him getting ILR.
And this is the, sorry, what date is this?
So this is the consideration of the decision that preceded the grant of ILR.
Yes.
So that would be 2010.
And then what we know from the core bundle at page 88 is that the application is successful and it's granted, unsurprisingly, given what we've just seen in the notes.
Yes.
So that, we say, puts a completely different complexion on Mr. Southwick's submissions this morning. So that's the first factual area to explore. The next stage was the naturalisation decision. Now, there was a form and a guide, and both of those were included in the Secretary of State bundle for the first
I think
tier.
there's a minor intervening stage that's referred to in the decision letter, which is his application for a travel document,
Yes.
which he maintains.
Yes, yes, he
Right.
does, and we refer to that in the skeleton.
Yep.
Your ladyship's quite right.
And it's in the decision letter.
So then comes the naturalisation, and at page 52,
Of,
the supplementary bundle. I'm just
Yes.
checking. Oh, no,
Yes.
It's, I think. The right. We're now on page numbers on the right-hand side of the page. If the court looks for page 51,
51, no, it starts at 52, although illegible when it doesn't appear. This is the application for naturalisation,
Yes.
December 2012.
yes, that's right.
The first, I go from the first page to page 53.
There's a. Oh yes, that's right. I'm sorry, I'm looking at the wrong thing. Absolutely. So page 51, because there isn't a page number 52. The cover page is on page 52, but you
Yes.
can't see the page number. And then there's the application
Yes.
and paragraph question 3.16 on page 61.
61. Yes.
Have you ever engaged in any other activities which might indicate, it's bottom hole punch, which might indicate that you may not be considered a person of good character? No.
Have you?
And 1.12 is where he says he was, and 1.13 where, is there anything about truth here?
That's where he says he's Kosovan. Country of birth Kosovo. Your present nationality 1.9 Kosovo. Did I hear your lordship?
Yes. Was there anything about this being a truthful answer?
Yes,
Section 6.
Declaration section 6, page 65. There's a whole series of warnings on that page. So underneath the signature block, there's a declaration, and then importantly also at 6.2, between the hole punches, he confirms he's read and understood the guide AN, and at 6.5 he understands that a certificate of citizenship may be withdrawn if it's found to have been obtained by fraud and so on. And he confirms again at the top that this is true. And then guide AN is at tab, I'm sorry that it's here, but it's in tab 48 of the authorities bundle.
Can we put away the supplementary bundle?
Yes, I think you can.
But it also, I mean, just to go back to the beginning of the application, in bold at the very top of the application, before completing this form, you should read the guide AN as well as booklet AN.
Yes. So guide AES tab 48 of the authority bundle, December 2012.
48.
48. This is the right version for this appellant. And then at page 1179 of the authorities bundle, there's a section on good character.
Sorry, which page?
At 1179,
Thank you.
section 3, and the key passage that we've sidelined is on page 1180 between the hole punches.
Right.
And unsurprisingly, there's also guidance on declaration by the applicant and so on. And there's also a warning what we expect from you on 1191, which is about telling us anything that changes. Not directly relevant in this case, but if anybody were in any doubt that the Secretary of State wants to know everything, this guide would disabuse them of that idea. So that's the application. Of course, the next stage is that the Secretary of State decides it, and Mr. Southey has already taken the court to the relevant internal guidance on good character, and that's at tab 47, and we know that that's referred to at Annex S of the decision letter. Now, the court's already looked at that with Mr. Southey. We don't need to go back to it. Suffice it to say that I rely on paragraph 9.1 and paragraph 9. I'm sorry. We do need to go back to it. Could I ask the court to turn up 1165?
You're going to take us to example B.
Yes, I was quite right.
You
So-
said you rely on 9.5. You said 9.1.
9.1 and then
Right.
9.5.1.
Sorry.
So 9.1 is the introduction. Count heavily any attempt to lie or conceal the truth about an aspect of... So in a different world where at this point the Secretary of State knows about the deception, we've seen from Mr. Matusha's case on similar facts, she did decide that the naturalisation application should be refused on good character grounds, and that's consistent with this guidance. The reason in Mr. Matusha's case was because it mattered. He'd employed deception at an earlier stage. So 9.1 and then 9.5.1, where there's evidence to suggest that an applicant has employed fraud either during the citizenship application process, tick, although of course the Secretary of State doesn't know that yet, or in previous immigration application processes, tick, and in both cases the fraud was directly material to the acquisition of immigration leave or to the application for citizenship, caseworkers should refuse the application unless the circumstances of 9.5.2 apply, and 9.5.2 is deception was factually immaterial to the grant of leave. Now, I hope I've shown by looking at Matusha that it is very difficult to see how this applicant could say, yes, my lies were factually immaterial to the grant of leave because it all turned on long residence, because what we've seen is that character was very much taken into account before any leave was granted under the legacy programme. And we've seen that Mr. Mustafa, referred to in Matusha, was refused leave, and Mr. Matusha himself had his leave revoked. So in my submission, this appellant is completely outside 9.5.2 of the guidance. It's not factually immaterial. By his lies, he ensured that he didn't fall into the same position as those two individuals. Example B is somebody being granted ILR under a family concession. Well, that's completely different. it's not talking about somebody who's lied their way through the legacy programme. So the example that's given in B is deception wasn't material to the grant of ILR, as regardless of the fact that he claimed to be Kosovan, he would in any event have been granted ILR under the concession as a result of his family arrangements. Well, that's not true of this appellant, because had he told the truth, his position would have been different under the legacy programme. We've just seen that. So in my submission, that really blows the reliance on example B out of the water.
Would Mr. Southey made a point saying it must be inferred that the person would have continued the lie in that case?
Yes, this is. I agree with Ms. Suffolk. This is assuming that the Secretary of State knows at the point that they're deciding the citizenship application that there has been deception. Of course, it makes it worse if the lie is then continued, which deprives the Secretary of State of the opportunity to consider her own good character guidance. Because by lying, a person puts themselves in a better position. They ensure that the Secretary of State, assuming that she doesn't uncover it, they stop the Secretary of State from considering whether there's been deception such that citizenship shouldn't be granted. They get the citizenship, and then all that the Secretary of State can do, if she finds out later, is deprive them of it. But by that lie, and that's absolutely true of this appellant, he ensured that he got ILR because he deprived the Secretary of State of the opportunity to consider his character, and he continued to lie and not to reveal the fact that he previously lied in his citizenship application, thereby depriving the Secretary of State of the opportunity to apply this guidance to him. And one can only assume that he did that so that he succeeded in his applications.
And so on your submission, the penultimate sentence of example B, on which Mr. Southey relied, doesn't apply, because you say there is no previously disregarded fact, because the Secretary of State didn't know that he told the lie, and B, in any event, good character was relevant to the grant of ILR.
Yes, exactly. So it's not what example B is getting at. And either this guidance or a very similar form was the guidance in place in 2013 when Mr. Matusha, his naturalisation application failed. We've seen that from the facts of that case. So that, if the court wants an example of how this guidance is applied in practice, there it is.
Do you have the guidance, if you're going to make that point, in relation to Mr. Matusha, do we have the 2013 guidance?
I can check if it's any different. One moment. Can I come back to
Of course.
on that point?
Yeah, sorry to be detailed.
We've got at tab 52 the October 2013 version, because that's relevant to the Ahmed case. But what I need to check is that there isn't a version in the middle. But certainly the October 13 version has a section on deception and dishonesty at 1296. But I won't try and wing that. I'll come back if I may.
Yeah, it doesn't seem to have the examples A, B, and C.
No. What it has at 8.2D is providing false or deliberately misleading information at earlier stages of the immigration application process.
Yes.
So that's that, and what we know is that those passages, 9.5.1 and 9.1, are directly referred to in the decision letter. So that then takes me on to the third stage, which is the deprivation decision. And apologies to pull out the supplementary bundle again, but just for the court to know, the court has the representations which were put in by the appellant when he was warned that the Secretary of State was considering depriving him. They're in the core bundle at page 67. Of course, a point that my lady made earlier in argument was that the decision letter has to be read in light of the representations which were made. Those appear in the core bundle at page 67. Could I ask the court to turn to page 70, the paragraph, this is the core of the submission that was made to the Secretary of State. Page 70, our client's case is on all fours with Sleeman. Our nationality had no bearing on the decision to grant him ILR. It wouldn't have mattered if our client was in fact Kosovan or Albanian or indeed any other nationality. He was a failed asylum seeker who was still in the UK. During the course of the legacy scheme, it was his length of residence in the UK that prompted the grant of ILR. No mention there of the fact that good character is relevant to an assessment of paragraph 395C and leave under the legacy scheme. So that's all that the Secretary of State gets by way of representations, and then I won't take up time now with the decision.
So in other words, the focus of the representations is whether the lie was relevant to the grant of ILR.
Yes.
Yep.
And it's really a very unattractive argument, which is, well, I know I've lied, but if I hadn't lied, I would have got leave. But that's really rather missing the point, because as the Supreme Court said, and I think it's in the Zurich case, which we may refer to in the other case, if you've told a lie, what you can't do is say, oh, well, if I hadn't told the lie, this would have happened to me, because the lie has deprived the person of the opportunity to know the truth. And here we say the lie has deprived the Secretary of State of the ability to apply her own guidance in full knowledge of the facts.
The decision letter in paragraph 17 deals with, I think, what was said at paragraph 70, or page 70, sorry. Is that right?
Yes.
But
so
it introduces, it's not in the reasons here, or the reasons advanced on behalf of the appellant, introduces this, you would have been removed from the UK to Albania if the immigration case, so it introduces this removal issue. Do you see?
Yes, that's right, yes.
Which seems to, but that's not the essence of the case.
Yes, and the
So-
real...
Doesn't matter. Why was that introduced? You're saying it just happens to be in the letter.
Simply a point that the decision maker sought to make, but the real point is this.
Well, I suppose it's a point that the decision maker made in response to that particular argument.
Yes.
Because you wouldn't have had your qualifying ILR if you weren't in the country.
Yes.
So it's a riposte to the argument.
Yes, and the point the other side makes is, well, he wouldn't have been removed. Well, one doesn't know what would have happened if he told the truth, because he was here without any leave, because he was a failed asylum seeker. But it doesn't matter, because the real point is paragraphs 18, 19, 20, and 21.
Yes.
Which gets into the guidance that the Secretary of State has applied.
Which is the contention, or the state assertion, that a material fraud was perpetrated at the time of the application for, or at the time of the acquisition of ILR status and citizenship.
Yes, exactly. And paragraph 18, chapter 55, as Mr. Southey has shown you, is the Secretary of State's guidance on
Yes.
deprivation. So
Yes.
the fact that the decision maker says chapter 55 state shows that he is the decision maker giving reasons by reference to the Secretary of State's guidance as to why he's being deprived. And it says the evidence shows that you perpetrated material fraud, claiming that you're a national of Kosovo in order to acquire ILR status and citizenship. Well, that's compressed reasoning, but I've just shown the court why that's true on both counts. And then at paragraph 19, there's a direct reference to section 9.1 of the good character guidance in the staff instructions. The Secretary of State correctly says, refers to 9.51 and 9.2, but says you would have been refused British citizenship had the nationality caseworker been aware that you presented a false place of birth to the Home Office, and continue to do so, and indeed that is what happened to Mr. Matusha. And then paragraph 20, despite having your asylum claim refused, you persisted with the deception. But had the truth been known that you were truly an Albanian national, it's likely you wouldn't have met the mandatory requirement to possess settled status. Well, what we do know is his decision under the legacy scheme would have been made in full knowledge of his deception.
And that's in the context of the recitation between paragraphs 10 and 15 of the 4 separate occasions on which the appellant had declared that things were true that weren't true,
Yes,
in knowledge of the consequences of the false
Yes.
declaration.
exactly. So this is a decision letter, not a statute. It's quite clear, we say, particularly when one reads everything in context, reads 18, 19, 20 and 21, that the Secretary of State is saying if you had told the truth, your naturalisation application would have been refused, therefore the test in section 40 is satisfied. And coming back to the statutory language, the Secretary of State is saying, I am satisfied that your registration or naturalisation was obtained by means of fraud, false representation or concealment of a material fact for those reasons. Paragraph 21. Your application would have been unsuccessful if you had told the truth. Now, pausing here, I won't get into Begum, but it is important to understand that it's not quite the way that Mr. Southey puts it, because what we see in this case is that the Secretary of State is the person who knows whether or not she would have been misled, whether or not she has been misled, because it's her guidance that she applies. She makes the decision on citizenship if she is satisfied, amongst other things, that the person is of good character. And it's the Secretary of State who knows that she has been misled. And I'm only really trailing a submission I'll make later, but in terms of institutional competence, it's the Secretary of State that's institutionally competent to say that she has been misled, as she does with this appellant. The other thing that the court will see from this letter is that it is an evaluative assessment, just as the question of good character is an evaluative assessment, so is the question of whether the condition precedent is satisfied. It's not, this case is a good example, and we haven't been shown a case where there's a simple question of fact, but that is an evaluative assessment. Did your deception have a material bearing on the grant of citizenship, or in the language of the legislation, was the registration obtained by means of fraud? It's not a factual question like, well, did you steal a Mars bar from the shop? It's different in my submission, and this case is an example of that. So,
Well, I suppose it could be said that it might be broken down into a factual component and an assessment. In other words, was there in fact a fraud? And if so, did that fraud have a bearing?
yes, I accept that. And in this case, the factual question, and in many cases, the answer that there won't be a question about the facts.
I mean, in this case, it's not disputed that there was a lie, but in some cases, people will argue that they didn't tell a lie. There was
Yes.
no fraud at all, and they would like the FTT to find that they didn't tell a lie.
Yes.
So in those cases, is it open to the FTT to make findings of fact about whether or not there was a fraud?
We say not, and I'll explain
Right.
why based
All right,
on
okay.
Bogan.
I just
Yes.
wanted to be clear.
Yes.
Yeah.
But we say fundamentally that the question is, was the Secretary of State entitled to be satisfied that the registration or naturalisation is obtained by means of fraud, false representation or concealment of a material fact? And it won't be the only instance in the immigration context where simply because there's dishonesty, there is not the court doesn't decide that question for itself. It's judicial review. And one of the examples there is the case of Giri, which I can take the court to tomorrow.
Yeah.
And you'll deal with how fresh evidence is going to affect the court's assessment of the Secretary of State's decision,
Yes. I will.
which is, as you know, very unusual. I mean, judicial review, we would never have fresh evidence.
Yes.
I suppose there might be an exception. I'm just thinking of there's that A and Croydon, which is the age assessment case,
Yes.
where the Supreme Court held that question whether or not a person is a child, surprisingly perhaps, but anyway, that's the law, is a question of fact for the court, even on an application for judicial review.
Yes, that's right.
So,
And there's the Kawaja case, which is the old
Yes.
precedent fact
precedent
case,
fact, yeah.
which is in the bundles and which we can look at tomorrow night. And I understand Mr. Malik is relying on it. Mr. Southey.
Just because it may assist, and particularly given that everyone's on a break, the precedent fact doctrine also extends to, which are very rare, but from memory, it extends to the issue of whether someone's a British citizen. If you have a judicial review where you're arguing I am a British citizen and so not
Yeah.
subject to immigration control, my memory is that the case law says at that stage the court decides directly whether you are a British
Is
citizen.
there a statutory presumption that the passport is enough to
It-
show it?
It is, but you do get odd sort of case
Yeah.
where there is an actual where either the Secretary of State is saying, for example, you obtained your passport by fraud, or if there's no passport at all, then
Yes.
Right.
Okay. Have you completed your submissions on?
I have, yes. So that may be a convenient place to stop if that suits the
Yes.
court. I was about to come on to the appellant's ground of appeal, so I can save that for tomorrow.
All right. And how long do you think it'll be tomorrow? Just roughly.
An hour?
Thank you.
To include the Bacon point.
Yes, maybe an hour and a half. Take what council says and add on half an
Well,
hour.
and it does depend on questions. I acknowledge that. Okay, so 10:30 tomorrow.
Thank you, Lord.
All right.
thank you.
I think you're right about that. I've not looked at it for ages, but I